Hello everyone, I'm delighted to be with you today to talk about the Treasury share regime for Hong Kong and certain overseas companies listed on the Hong Kong Stock Exchange and the company redomiciliation regime in Hong Kong, which came into effect in May 2025. During the course of today's webinar, for the first part on the Treasury shares regime, I'm going to be discussing the reasons for the Stock Exchange's decision to introduce the Treasury share regime and then go through the key listing rule requirements for Treasury shares, including the requirements for sales of Treasury shares, as well as the amendments made to the Companies Ordinance to allow Hong Kong listed companies to hold shares which have been bought back as Treasury shares. In the second part on the company redomicile regime in Hong Kong, I'll outline the requirements to redomicile an overseas company to Hong Kong. In 2024, the Hong Kong Exchange amended the listing rules to allow companies listed on the Hong Kong Exchange, which I'll talk about as listed companies, to repurchase their own shares and hold them in Treasury for future resale, provided this is allowed under the laws of their place of incorporation and their constitutional documents. Whether or not a company can repurchase its own shares and the status of repurchased shares is governed by the laws of its jurisdiction of incorporation and its constitutional documents. Under the previous listing rules, however, a listed company's repurchase of its own shares resulted in the automatic cancellation of the listing of those repurchased shares. The company was required to ensure that the documents of title of the repurchased shares were cancelled and destroyed immediately following settlement of any repurchase. This prevented listed companies from holding their repurchased shares in Treasury, even where this was allowed under the laws of their home jurisdiction. The previous listing rule requirements reflected the requirement under the previous Hong Kong Companies Ordinance for all Hong Kong incorporated companies to cancel repurchased shares. The listing rule requirement to automatically cancel the listing of all repurchased shares was originally introduced to safeguard against the risk of market manipulation by listed companies repeatedly repurchasing and reselling their own shares on the market, and also to mitigate risks of insider trading in the shares with the benefit of non-public information about share repurchases and resales of Treasury shares. Today, over 90% of companies listed on the Stock Exchange of Hong Kong are incorporated in jurisdictions that permit the holding of Treasury shares. These include mainland China, Bermuda, and the Cayman Islands. But all these companies were previously prevented from holding Treasury shares by the earlier listing rule requirement to cancel the listing status of any shares they repurchased. Insider dealing and market manipulation involving Treasury shares are today subject to the civil and criminal provisions of the Securities and Futures Ordinance. As I'll talk about later, the listing rules also set out various restrictions on share repurchases and resales of Treasury shares, which are intended to further mitigate those risks. Subsequent to the changes to the listing rules, amendments to the Hong Kong Companies Ordinance came into effect on the 17th of April 2025, which exclude companies listed on a recognized stock market from the requirement to immediately cancel any repurchased shares. The amended Companies Ordinance effectively allows companies incorporated under the Hong Kong Companies Ordinance to benefit from the Treasury shares regime and align with international practice. The rationale for allowing listed companies to hold their repurchased shares in Treasury and to resell them when market conditions are favorable was to allow them to quickly adjust their share capital, which may allow them to reduce their cost of capital. With the implementation of the Treasury share regime, listed companies can, for example, resell their Treasury shares in small lots on the market at full market price as an alternative fundraising means to placings, where companies usually sell new shares at a discount to market price. Companies may repurchase shares for a number of reasons depending on their local law. This may include returning cash to shareholders, adjusting debt to equity ratio, increasing earnings per share, or other metrics based on the number of outstanding shares, facilitating the exit of shareholders from the company, or signaling to the market that its shares are undervalued. The requirement for listed companies to cancel repurchased shares has now been removed, and listed companies are now able to hold repurchased shares in Treasury as permitted under the laws of their place of incorporation and their constitutional documents. Treasury shares also retain their status as listed shares, provided that they remain issued shares under the laws of the listed company's home jurisdiction. Listed companies wishing to hold and sell Treasury shares should take advice on the provisions of their local laws regarding the holding, use, and sale of Treasury shares and make any necessary amendments to their constitutional documents to allow them to hold, use, and sell treasury shares as permitted by those laws. Treasury shares are defined in Listing Rule 1.01 as shares repurchased and held by an issuer in treasury as authorized by the laws of the issuer's place of incorporation and its articles of association or equivalent constitutional documents, which for the purpose of the rules include shares repurchased by an issuer and held or deposited in CCAS for sale on the exchange. A note to that definition clarifies that treasury shares can be held by a listed company's subsidiary or an agent or nominee of the listed company or its subsidiary if this is allowed by the laws of the company's jurisdiction of incorporation and its constitutional documents. For example, under the laws of Bermuda and the Cayman Islands, repurchased shares must be held in the company's own name in order to be classified as treasury shares. Mainland Chinese law, on the other hand, does not require Treasury 8 shares to be held in the name of the listed company, although shareholders' rights attached to repurchased shares repurchased by the listed company will be suspended, irrespective of whether they are held by the listed company or a nominee. The listing rules don't restrict how treasury shares can be used. Their use will depend on the laws of the company's home jurisdiction and constitutional documents. Depending on the jurisdiction, treasury shares can be used as consideration shares or for satisfying employee share schemes or for conversion of convertible securities. The laws of a company's home jurisdiction will generally provide that shareholders' rights, such as voting rights and the right to participate in distributions, are suspended for treasury shares and reinstated when the treasury shares are sold or transferred out of treasury, although the requirements differ according to jurisdiction. To ensure that treasury shares are treated differently to listed companies' regular listed shares, Listing Rule 10.065 imposes an obligation on listed companies to ensure that treasury shares are appropriately identified and segregated. When I refer to specific listing rules, I'm talking about the main board listing rules, although the GEM listing rules do contain equivalent provisions. The Hong Kong Exchange has published Guidance Letter 119/24, which includes guidance on how listed companies can meet the obligation to identify and segregate their treasury shares in CCAS. The guidance letter notes that listed companies can hold treasury shares that they intend to resell with CCAS registered in the name of HKSCC Nominees Limited as a common nominee. To enable treasury shares held in CCAS to be identified, listed companies are required to hold their treasury shares in a segregated CCAS account. The segregated account can be opened by the listed company's broker or custodian, provided that it holds the listed company's treasury shares separately from the securities belonging to its other clients. The guidance letter outlines the different arrangements that apply where the laws of the listed company's home jurisdiction require treasury shares to be held in the listed company's own name as compared to the arrangements that apply to listed companies whose treasury shares can also be held in the name of the listed company's nominee. Where the listed company is incorporated in a jurisdiction which requires repurchased shares to be held in its own name in order to be classified as treasury shares, such as Bermuda and the Cayman Islands, the company should withdraw the repurchased shares from CCAS on completing a share repurchase and register them in the company's own name in its register of members. The listed company should only redeposit the treasury shares into CCAS if it plans to resell them on the stock exchange imminently. Although the repurchased shares are no longer classified as treasury shares under the relevant laws, once legal title is transferred to HKSCC nominees on deposit of the shares into CCAS, the listing rules will treat the repurchased shares in the same way as treasury shares because they're beneficially owned by the listed company. On depositing repurchased shares into CCAS, the listed company is required to give clear written instructions to its broker and share registrar that the repurchased shares are to be treated as treasury shares under the listing rules. Pending resale of the repurchased shares on the exchange, the listed company is required to put arrangements in place to ensure that it will not exercise any shareholders' rights or receive any entitlements which would be suspended under its home laws if the shares were registered in its own name as treasury shares. The guidance letter suggests that a listed company could obtain board approval that the listed company procure its broker not to instruct Hong Kong Securities Clearing Company Limited to vote at general meetings for the treasury shares deposited with CCAS. In the case of dividends and distributions, guidance letter suggests that the listed company should withdraw the treasury shares from CCAS and either re-register them in its own name as treasury shares or cancel them before the record date for the dividend or distribution. Conversely, if the laws of the listed company's place of incorporation, such as the PRC, don't require treasury shares to be held in the listed company's name, shareholders' rights attached to the shares will be suspended under the relevant laws once the shares are repurchased by the listed company, regardless of whether they're held in the own name of the company or that of a nominee. In this case, the listed company should hold the repurchased shares as treasury shares in a segregated account in CCAS. After completing the share repurchase, the listed company must provide clear written instructions to its share registrar and the relevant broker to update the record to identify the repurchased shares held in CCAS as treasury shares. On-exchange share repurchase are subject to various restrictions under the listing rules. When I use the term on-exchange, I'm talking about a transaction conducted on the Hong Kong Stock Exchange or any other stock exchange on which the company is listed. First, companies with a primary listing on the Hong Kong Stock Exchange, including those with dual primary listings, must obtain shareholders' approval to repurchase their shares on exchange under a specific mandate or a general mandate. That mandate must limit the number of shares the company is authorized to repurchase on exchange to 10% of the company's issued shares, excluding treasury shares, at the date of the shareholders' resolution approving the repurchase mandate, Listing Rule 1006(c)(1). Listed companies are also prohibited from repurchasing their shares on exchange at a price that's higher by 5% or more than the share's average closing price for the 5 preceding trading days. Listed companies on exchange share repurchases are also subject to various restrictions on dealing and disclosure obligations, which I'll discuss shortly when I talk about the restrictions applicable to on exchange resales of treasury shares. A resale or transfer of treasury shares is subject to preemption rights similar to an issuance of new shares under Listing Rule 1336. This means that a resale or transfer of treasury shares must either be offered to all the listed company shareholders on a pro rata basis, or it must be approved by shareholders under a specific mandate or a general mandate. A general mandate must specifically authorize the resale of treasury shares. The general mandate limit will then apply to both the issue of new shares and the resale of treasury shares. The limit under the general mandate on the number of new shares that can be allotted and the number of sales and transfers of treasury shares is the aggregate of 20% of the listed company's issued shares, excluding treasury shares at the date of the resolution granting the mandate, and the number of shares repurchased since the grant of the general mandate up to a maximum of 10% of the company's issued shares, excluding treasury shares, at the date of the share repurchase mandate. A listed company can only add shares repurchased on exchange under the repurchase mandate to the general mandate limit and not shares repurchased off exchange. If treasury shares are resold on exchange under a general mandate, the resale is subject to a maximum price discount of 20% of the higher of the closing price on the trading day immediately prior to the resale and the average closing price in the 5 trading days immediately prior to the resale. Similarly, an off-market resale of treasury shares under a general mandate for cash consideration is subject to a maximum price discount of 20% of the higher of the closing price on the date of the agreement for the resale of the treasury shares and the average closing price in the 5 trading days immediately prior to the earlier of the date the resale is announced, the date of the agreement for the resale of the treasury shares, and the date on which the resale price is fixed. For listed companies incorporated in China, Listing Rules 1005 and 1006 only govern repurchases of shares listed on the Hong Kong Exchange. That's their H shares. PRC companies' repurchase of A shares are not covered by the requirements of Listing Rule 1336. Under PRC law, A and H share issuers do not need to cancel their Treasury A shares and can hold and use repurchased A shares to satisfy employee share schemes for the conversion of convertible securities or for resale in the open market to stabilize their share price. The holding and use of Treasury A shares only requires board approval. Similarly, the resale of Treasury A shares is not subject to the Listing Rules shareholders' mandate requirements since they're not listed on the Hong Kong Exchange. However, an A and H share issuer is required to provide information on its repurchases of A shares in the explanatory statement for seeking shareholders' approval for repurchasing H shares on the exchange. It also has to report its repurchases of A shares in next-day disclosure returns and its annual reports. The definition of treasury shares in Listing Rule 101 provides that a resale of treasury shares by a listed company or its subsidiary includes a resale of treasury shares through their agents or nominees. The effect of this is that the various requirements applicable to resales of treasury shares also apply where the resale is effected by an agent or nominee of the listed company or its subsidiary. The resale or transfer of treasury shares to connected persons is subject to the same connected transaction requirements as a new issue of shares under Chapter 14A. Treasury share resales and transfers to connected persons therefore require independent shareholder approval unless exempted under Listing Rule 14A-92, which provides exemptions for, amongst other things, pro rata issues to existing shareholders and shares issued under a share scheme that complies with Chapter 17 of the Listing Rules. An on-exchange sale of treasury shares is also exempt from all the requirements for connected transactions, provided that the connected person does not know that it is purchasing treasury shares from the listed company. Share schemes can use treasury shares to satisfy share grants if this is specifically allowed under the scheme rules. These schemes are treated as share schemes funded by new shares under Chapter 17 of the Listing Rules, and grants of shares under the scheme are subject to the scheme mandate limit approved by shareholders under Chapter 17. If listed companies amend the rules of their share schemes to authorize the use of treasury shares to satisfy share grants, the exchange does not regard this amendment as a material alteration to the scheme rules requiring shareholders' approval under Listing Rule 1703(18). Listed companies are required to publish an announcement on the grant of share awards or options under a share scheme. They also need to file a next-day disclosure return if they transfer treasury shares to a director under a share scheme. Transfers of treasury shares to share scheme participants other than directors require a next-day disclosure filing only when they result, together with other events specified in Listing Rule 1325A2B, in a change of 5% or more in the listed company's issued shares since the last next day or monthly returns submitted. As I mentioned earlier, the prohibitions against stock market manipulation and insider dealing under the Securities and Futures Ordinance apply to treasury shares. The listing rules additionally set out various dealing restrictions applicable to share repurchases and sales and transfers of treasury shares that are intended to mitigate the risks of these activities. A listed company with a primary listing on the Hong Kong Exchange can't sell or transfer treasury shares for 30 days after a share repurchase, whether conducted on exchange or otherwise, except with the exchange's approval. This restriction does not, however, apply to sales or transfers of treasury shares under capitalization issues, such as bonus issues and scrip dividends, on the vesting or exercise of share awards or options under a share scheme that complies with Chapter 17, or pursuant to an exercise of warrants, share options, or similar instruments that require the listed company to transfer treasury shares which were outstanding before the share repurchase. The Stock Exchange has clarified in its FAQs that these carve-outs also apply to a transfer of treasury shares by a listed company on the conversion of convertible securities which were issued with subscription monies settled in full before the share repurchase. This 30-day moratorium also applies to dual-listed companies. However, the moratorium requirement does not apply to the resale of Treasury A shares by a PRC company with H and A shares listed on the Stock Exchange and a PRC stock exchange, respectively. Listed companies with a primary listing on the exchange are also prohibited from purchasing their shares on the exchange within 30 days after an on-exchange sale or transfer of Treasury shares. Listed companies are also prohibited from reselling Treasury shares on exchange at any time when they have undisclosed inside information and during the period starting 30 days before the earlier of the date of the board meeting held to approve the listed company's financial results for any period and the deadline for the announcement of those results, and ending on the date of the financial results announcement, Listing Rule 1006A3. Listed companies are also prohibited from repurchasing their shares on exchange in the same circumstances under Listing Rule 10.06(2)(e). Listed companies are further prohibited from knowingly repurchasing their shares from or knowingly selling treasury shares to a core connected person in an on-exchange transaction. A listed company's core connected persons are similarly restricted from knowingly selling the company's shares to or knowingly purchasing treasury shares from the listed company in an on-exchange transaction. Where a listed company appoints a broker to effect a repurchase of its shares or a sale of its treasury shares, it's required to procure that the broker provides the stock exchange with any information it requests in relation to the share repurchase or sale of treasury shares. New listing applicants can retain their treasury shares after listing. The new listing applicant must disclose details of its treasury shares in its prospectus. However, newly listed companies cannot sell or transfer their treasury shares or enter into an agreement for the sale or transfer within 6 months after listing. However, an exception from the 6-month lockup on transfers of treasury shares is available for a transfer of treasury shares under a Chapter 17 share scheme. A company that has transferred its listing from GEM to the main board is also allowed to sell or transfer treasury shares as an exception to the 6-month lockup requirement if it disclosed its plan to raise funds within 6 months of the transfer of its listing to the main board in its listing document or in the announcement of its transfer to the main board where the company transferred to the main board under Chapter 9B of the listing rules. When seeking a share repurchase mandate from shareholders, a listed company must send an explanatory statement to its shareholders with the notice of the general meeting being held to approve the share repurchase mandate. The explanatory statement has to set out specified information, including the number and type of shares it proposes to repurchase, the reasons for the proposed repurchase, and the proposed source of funds. Listed companies must also state in the explanatory statement whether they intend to cancel the repurchased shares or hold them in treasury. In its FAQs, the exchange confirmed that a listed company can say in its explanatory statement that it may cancel its repurchased shares and/or hold them as treasury depending on market conditions and its capital management needs at the time of the share repurchases. Share repurchases conducted on exchange or off exchange must be disclosed in a next day disclosure return published on the business day following the repurchase. This must give the total number of shares repurchased, the price per share, or the highest and lowest prices paid, whether the repurchased shares are cancelled or held as treasury shares, and the reasons for any deviation from the listed company's statement of its intention to cancel or hold repurchased shares as treasury shares, given in its explanatory statement. A listed company must include in its annual report a monthly breakdown of its share repurchases, showing the number of shares repurchased each month in both on-exchange and off-exchange transactions, the purchase price per share or the highest and lowest price paid, and the aggregate price paid for all share repurchases must also be disclosed in the annual report. Disclosure of listed companies' on-exchange resales of treasury shares must be made in a next day disclosure return under Listing Rule 10.06(b)(1). A separate announcement of an on-exchange resale of treasury shares is also required if the resale, together with previous on-exchange resales of treasury shares in the previous 12 months that have not yet been announced, amounts to 5% or more of the listed company's issued shares, excluding treasury shares. Where an announcement is required, it must disclose the number of treasury shares sold during the year, the total funds raised, the reasons for the sales, and details of the use of proceeds. If the treasury shares are sold under a general mandate, details of the general mandate must also be given. Under paragraphs 11 and 11A of Appendix D2 to the listing rules, listed companies must disclose details of their on-exchange resales of treasury shares for cash in their annual reports. Annual reports must include a monthly breakdown of all on-exchange resales of treasury shares, showing the number of treasury shares sold each month, the selling price per share, or the highest and lowest prices received, the total funds raised, details of the use of proceeds, and the reasons for the resales. Disclosure must also be made of any treasury shares held by the listed company as at their year-end date and their intended use. Paragraph 41A of Appendix D2 to the listing rules requires the same information to be included in listed companies' interim reports. The annual and interim report disclosure requirements don't apply to the transfer of treasury shares under a share scheme that complies with Chapter 17 of the listing rules. Listed companies are required to report a cancellation of treasury shares in a next day disclosure return under Listing Rule 1325A2B7 when it results, alone or with other events under Listing Rule 1325A2B, in a change of 5% or more in the listed company's issued shares since the last monthly or next day return filed. Listing Rule 101 requires that listed companies that hold treasury shares must abstain from voting on matters that require shareholder approval under the listing rules. Since treasury shares are held by listed companies themselves and the rights attached to them are normally suspended under local laws, treasury shares are excluded when calculating a listed company's issued shares to determine matters such as public float, market cap, mandate limits, and size tests for transactions. They're also excluded when calculating percentages of rights to vote at listed companies' general meetings, including for the purposes of the definitions of controlling shareholder and substantial shareholder. The SFC's Takeovers Code and Share Buybacks Code are principally concerned with voting rights. The voting rights of treasury shares are typically suspended, and even if they're not, the voting rights attached to treasury shares are explicitly excluded from the Code's definition of voting rights. This means that treasury shares are disregarded for the purpose of determining whether the Code thresholds are met. For example, the 30% trigger or 2% creeper for a mandatory general offer under Rule 26.1 of the Code, or the acceptance condition under Rule 30.2. It also means that a listed company's repurchase of its shares will result in an increase in its shareholders' percentage holding of voting rights if those shares are held as treasury shares, in the same way as if the shares were cancelled. If a shareholder's voting rights then exceed the trigger or creeper threshold, this will normally trigger the obligation to make a mandatory general offer unless the shareholder is not a director of the listed company nor a party acting in concert with a director of the listed company. Treasury shares are not regarded as part of a listed company's outstanding share capital. Accordingly, when an offer or partial offer is made for a listed company's securities, the offer does not need to include the company's treasury shares. Treasury shares are not considered to be disinterested shares for the purposes of the voting or acceptance percentage requirements under Rules 2.2, 2.10, and 2.11. Similarly, neither the listed company nor its nominees are regarded as disinterested shareholders under the Share Buybacks Code. Detailed guidance on the treatment of treasury shares under the SFC's Takeovers Code and Share Buybacks Code is set out in the SFC's Practice Note 26. For the purposes of the disclosure of interest regime under Part 15 of the SFO, treasury shares remain part of a listed company's issued voting shares, notwithstanding any suspension of the voting rights attached to them. This means that treasury shares must be included in the number of the listed company's shares in issue when calculating the percentage figure of a person's interest. However, there'll be no change to the percentage figures of shareholders' interests when a listed company chooses to hold any repurchased shares in treasury or resells its treasury shares. A further consequence is that a listed company that acquires an interest of 5% or more of its own shares by holding those shares in treasury will need to file a disclosure of interests notice. It will also need to file further notices on any change in the percentage level of its interest. A change may occur, for example, on a further repurchase of its own shares or on a resale or transfer of treasury shares. Moving on to the treasury share regime under the Hong Kong Companies Ordinance, the legal framework governing treasury shares and requirements in relation to their acquisition and disposal and the suspension of associated rights attached to treasury shares are set out under Subdivision 8 of Division 4 of Part 5 of the Companies Ordinance. These requirements apply to listed companies formed and registered under the current Companies Ordinance or its predecessor ordinance and listed companies that have re-domiciled to Hong Kong. And I'll talk about these companies together as Hong Kong listed companies. The treasury shares regime only applies to listed companies, and the Hong Kong Companies Ordinance still regards shares repurchased by non-listed private and public companies incorporated in Hong Kong as cancelled on repurchase. A Hong Kong listed company that repurchases its own shares now has the option to hold those shares as treasury shares, either in its own name or through a nominee. Once held in Treasury, these shares may be disposed of by three distinct methods: cancellation, transfer, or sale. The amended Companies Ordinance also makes it clear that if a company listed on the Hong Kong Exchange holds Treasury shares that subsequently become delisted, all of its Treasury shares will be regarded as cancelled on the date of delisting. In line with the requirements of the listing rules that imposes a principle of preemptive rights, Section 272G of the Companies Ordinance also imposes similar requirements, stating that a transfer or sale of Treasury shares is subject to the same approval requirements as those that apply to the allotment of new shares under Sections 140, 141, 172A of the Companies Ordinance. This means that where the Treasury shares are not sold or transferred to shareholders on a pro rata basis in proportion to their current shareholdings, this can be done only with the approval of shareholders or pursuant to a general mandate which covers the resale and/or transfer of Treasury shares. After the Hong Kong listed company repurchases the shares to be held in Treasury, it must either enter its name or that of its nominee in the Register of Members. Regardless of whose name is in the Register of Members, under Section 272C of the Companies Ordinance, the holder of Treasury shares is generally not regarded as a member, shareholder, or contributory for the purposes of the Companies Ordinance or the Company's Winding Up and Miscellaneous Provisions Ordinance, except in relation to the annual return disclosure requirements. Section 272H of the Companies Ordinance says that all rights attached to Treasury shares are suspended while they're held in Treasury. This suspension is comprehensive and includes the right to attend and vote at general meetings, the right to receive dividends, and the right to receive any distribution of the Hong Kong listed company's assets, including any distribution of assets on a winding up. Treasury shares must also be excluded from calculations for the voting thresholds of corporate matters under the Companies Ordinance and the Company's Winding Up and Miscellaneous Provisions Ordinance, Cap 32, such as passing ordinary or special resolutions of members, calling a general meeting. Treasury shares are also excluded when calculating the threshold of shares required to be held by an offeror under Section 700 of the Companies Ordinance that will trigger the right of minority members to compel the offeror to acquire their shares in a takeover offer. Under Section 272I of the Companies Ordinance, Hong Kong listed companies are still permitted to allot fully paid bonus shares in respect of Treasury shares. These bonus shares, once allotted, are to be considered as having also been bought back at the time of their allotment. The Hong Kong listed company may decide whether to hold them as Treasury shares. If not, the shares will be regarded as cancelled on allotment. Under the amended Section 269 of the Companies Ordinance, on share buyback, a Hong Kong listed company must deduct the total amount of the price paid for the shares from the share capital if the shares were bought back out of capital, from its profits if the shares were bought back from profits, or reduce both proportionally if both were used. The act of holding the repurchased shares as Treasury shares after the buyback will not cause a change to either the amount of issued share capital or the total number of issued shares. If the Hong Kong listed company subsequently decides to cancel its Treasury shares, the number of issued shares is reduced by the number of shares cancelled without affecting the issued share capital of the company at this stage. When the Treasury shares are sold or transferred for a consideration, the amount of issued share capital will increase accordingly. However, the total number of issued shares will remain unchanged. This is because the shares, having already been issued, are simply being resold into the market rather than being created. In addition to the disclosure requirements under the listing rules, the amended Companies Ordinance also sets out reporting requirements that Hong Kong listed companies must observe when conducting share buybacks and dealing with the Treasury shares. After a Hong Kong listed company buys back its shares, it must deliver a Form NSC2 to the Companies Registry within 15 days of the date the shares are delivered to the company. This form has been revised with the implementation of the Treasury share regime and requires disclosures of the details regarding shares bought back that are being held as Treasury shares, including shares allotted as fully paid bonus shares in respect of Treasury shares, which will be regarded as being bought back by the company on allotment. If a Hong Kong listed company sells or transfers any of its Treasury shares, it's required to deliver a Form NSC 222, which is the return of sale or transfer of treasury shares to the company's registrar within 15 days of the sale or transfer date, which sets out information including the total number of treasury shares concerned, the date of the sale transfer, the consideration, and a statement of capital immediately after the sale or transfer. Where a Hong Kong listed company cancels its treasury shares, details of this cancellation must be notified to the company's registry using Form NSC 23, the return of cancellation of treasury shares, setting out the number of treasury shares cancelled, the date of the cancellation, and a statement of capital immediately after the cancellation. This form must be delivered to the company's registrar within 15 days after the cancellation date. Form NSC 23 is also required if a Hong Kong listed company becomes delisted and its treasury shares are considered cancelled. Generally, Hong Kong listed companies are required to disclose particulars of all members who hold not less than 5% of the issued shares of any class of the company's shares in its annual return submitted to the company's registrar. As I mentioned, the Hong Kong listed company or the nominees holding the treasury shares will generally not be regarded as a member who would be entitled to exercise members' rights. However, for the purpose of this disclosure requirement only, Hong Kong listed companies or nominees will be regarded as members of the company, meaning that the particulars of the Hong Kong listed company or the nominee must be disclosed in the annual return form if they hold 5% or more of the issued shares in any class of the Hong Kong listed company's shares as treasury shares. Other than the annual return disclosure requirements, the Companies Ordinance does impose periodic disclosure requirements with respect to the company's treasury shares held. Additionally, in terms of stamp duty, a resale of treasury shares in the secondary market constitutes a disposal of the shares for valuable consideration. The resale is therefore subject to ad valorem stamp duty under the Stamp Duty Ordinance. I'm now going to move on to talk about the company redomicile regime introduced by the Hong Kong Financial Services and Treasury Bureau, the FSTB. Schemes of redomicile date back to the 1980s in Hong Kong, when multinational conglomerates such as Jardine Matheson moved their places of incorporation initially from Hong Kong to Bermuda. When Jardine Matheson Holdings Limited was incorporated as the group's holding company in Bermuda at that time. Following this, the 80s and 90s saw a number of Hong Kong incorporated companies move their places of jurisdiction offshore to places such as Bermuda and Cayman. In recent years, Hong Kong has reintroduced fund redomiciliation regimes, which allow offshore funds established in the form of a company or limited partnership to redomicile to Hong Kong as open-ended fund companies or a limited partnership fund to attract foreign funds to Hong Kong. However, previous to this, there was no legislative regime in Hong Kong which allows companies incorporated in overseas jurisdictions to migrate their place of incorporation to Hong Kong while maintaining their legal status and the validity of their corporate actions prior to the redomicile. This is commonly known as inward redomicile or continuation. Previously, overseas incorporated companies that would like to redomicile to Hong Kong had to either wind up the company in its original place of incorporation and set up a new Hong Kong company, which would disrupt the overseas company's operations, as the company would lose its legal identity and its rights and liabilities under its existing contracts on winding up, or it could opt to enter into a court-sanctioned scheme of arrangement to convert into a wholly owned subsidiary of a Hong Kong incorporated company with the approval of the company's shareholders and other stakeholders. This method would involve the court, and the court procedures can be complicated, extensive, and costly. Also, this may not provide a complete exit, as the company may be subject to the laws of both Hong Kong and the original place of domicile. In the consultation paper regarding redomicile, the FSTB said that the opportunities the proposed regime offers for overseas incorporated companies that are economically active in Hong Kong to align their place of incorporation with the geographic location of their business activities while taking advantage of Hong Kong's high corporate governance standards and leading capital markets. Another relevant factor is that some low and no tax jurisdictions, such as Bermuda and the Cayman Islands, have increased their economic substance requirements and compliance costs in recent years. Following the FSTB's consultation conclusions published in July 2024, the Hong Kong Companies Ordinance was amended to introduce an inward redomicile regime, and this took effect in May 2025. The regime is administered by the Registrar of Companies, which is responsible for reviewing, approving, or rejecting applications for redomicile to Hong Kong. The Hong Kong Companies Registry has also set up a web page to provide information about the company redomicile regime and published a guide on company redomicile, setting out the eligibility for application, the application procedures, and documents. According to the consultation conclusions published by the FSTB, one of the main aims of the proposed inward redomicile regime was to allow for continuity of the company's business rights and legal identity while avoiding complex and expensive legal processes. Under Section 820D of the amended Companies Ordinance, the legal identity of redomiciled companies is preserved, and the redomicile process does not create a new legal entity. This means that all property rights, obligations, and contracts entered into are still effective against the redomiciled company, even though these were accrued prior to redomicile. All legal proceedings that can be taken by or against the overseas company can still be commenced or continued by or against the company after its redomicile to Hong Kong. Companies that have successfully redomiciled to Hong Kong will be treated as companies incorporated in Hong Kong on their redomiciliation date. In particular, Section 25A of the Companies Ordinance acts as a general deeming provision confirming this position. Redomiciled companies will benefit from the same rights and be subject to the same obligations under Hong Kong company law as other Hong Kong incorporated companies. The FSTB further clarified that these obligations include appointing a company secretary under Section 474 of the Companies Ordinance, which may not be required under the law of the original place of domicile of the company. Examples of other ongoing obligations also include requirements on the submission of annual returns and notification requirements for the appointment or cessation of a director of the company. For non-Hong Kong companies that are registered under Part 16 of the Companies Ordinance that apply to be redomiciled to Hong Kong, their status as a registered non-Hong Kong company would immediately cease to be effective on successful redomicile. The FSTB confirmed in its consultation conclusions that an outward redomicile regime will not be introduced at this stage, as the FSTB thinks that it's not aware of any demand for redomicile from Hong Kong to overseas jurisdictions. The FSTB stated that it would continue to monitor the merits of an outward redomicile regime and its potential impact on the development of Hong Kong markets. To apply for redomicile to Hong Kong, an overseas company has to satisfy a number of eligibility requirements. Under the Hong Kong company redomicile regime, the company must currently be in the same or substantially the same form as the types of company that can be incorporated under the Companies Ordinance. Given the aim of preserving the legal identity of the redomiciled company, companies would not be permitted to change their company type using the redomicile process. The overseas company must be a company type that is the same or substantially the same as the following four types of company. First, private companies limited by shares, then public companies limited by shares, thirdly, private unlimited companies with a share capital, and fourthly, public unlimited companies with a share capital. Companies limited by guarantee without a share capital would not be eligible for the proposed regime. Notwithstanding the limit on the type of eligible companies, applicant companies are not subject to an economic substance test under the company redomicile regime. The FSTB said in the consultation conclusions that it observed that economic substance tests are not common among other jurisdictions with an inward redomicile regime. So companies would only be required to meet the requirements regarding the nature of the company and other eligibility requirements, which include a solvency requirement, without being subject to minimum economic substance thresholds. Under the Hong Kong company redomicile regime, overseas companies would need to meet requirements in relation to legal compliance and the length of time since the company's been incorporated. The law of the company's original place of domicile must allow outward redomicile to other jurisdictions. For example, companies originally incorporated in Cayman may be eligible for this regime, as the Cayman Limited Liability Companies Act permits outward redomicile, whereas currently Singapore does not have an outward redomicile regime. Companies must also fulfill all the requirements for outward redomicile under the laws of the original place of incorporation. These may include shareholder approval, creditor notification, other approval requirements, and requirements to advertise the intention to redomicile to Hong Kong. For example, BVI companies are generally required to advertise their intention to redomicile to Hong Kong for 14 days, and Cypriot companies may be required to obtain prior consent from the Cyprus Registrar of Companies before submitting a redomicile application in Hong Kong. Also, the overseas company must have been incorporated for at least one financial year before submitting an application for redomicile to Hong Kong. If a company has previously undergone redomiciliation in another jurisdiction, the one financial year requirement starts to count from the effective date of the previous redomicile and not the initial incorporation date. The Hong Kong Registrar of Companies will also consider the integrity of the applicant overseas company and whether all application requirements under the Companies Ordinance have been complied with. The Registrar of Companies is mandated to refuse a redomicile application where it's of the opinion that the redomicile company is likely to be used for unlawful purposes or for engaging in activities that are against the public interest. The redomicile regime also requires that an overseas company must be able to pay all debts that fall due during the 12 months after the date of submitting the redomicile application, and there must not be any ongoing or foreseeable liquidation proceedings against the overseas company. The company must submit financial statements and other documents to prove the company's financial status. I'll talk about the documents that would need to be submitted with a company's application for redomicile in a moment. The amended Companies Ordinance also sets out approval requirements in relation to creditor and member protection. The application for redomicile must be made in good faith, and the arrangement must not be intended to defraud the company's creditors. If the overseas company has creditors, it's required to issue a notice of intention to redomicile to Hong Kong to all creditors and directors of the overseas company, to confirm in the certificate issued by the Board of Directors to be submitted with the application that a notice to this effect has been sent to all creditors. Each creditor must be notified, and publication of the notice in a gazette or local newspaper is not enough. The company's redomicile would also have to be approved by its members. If the law of the original place of domicile or the constitutional documents of the overseas company stipulates certain member consent requirements, this consent must be obtained, and a confirmation that these requirements have been fulfilled must be included in the legal opinion to be submitted as part of the application. However, if there isn't any such requirement, then the redomicile must be approved by way of a special resolution passed by at least 75% of the shareholders entitled to vote. As part of the application process, overseas companies will need to submit a number of documents set out under Section 820B and Schedule 6C of the Companies Ordinance to demonstrate that they meet the Hong Kong eligibility requirements for redomicile. The overseas company must submit a duly completed and signed application form. Some of the main information that applicant companies would be required to provide in the application form include the company's original and proposed name. The name of the company after redomicile must meet the restrictions on company names under the Companies Ordinance. For instance, the name of a private company limited by shares must end with the word limited or its Chinese equivalent. The company's original place of incorporation, whether the company is a registered non-Hong Kong company under Part 16 of the Companies Ordinance, the company type, the proposed registered office address and relevant contact details, particulars of the proposed directors and company secretary with the directors' consent to act as directors of the company after redomiciliation, particulars of existing directors and company secretary who will not continue to act as directors or company secretary after redomicile, and details of the overseas company's share capital and shareholders. The company must also submit a copy of the proposed Articles of Association that the shareholders of the overseas company have resolved to adopt with effect from the date the company is registered as a redomiciled company in Hong Kong. A certified copy of the certificate of incorporation of the company issued under the law of its original place of incorporation must also be submitted. If the company has undergone redomiciliation before, A certified copy of the certificate of registration must be submitted in addition to the certificate of incorporation issued under the law of its initial place of incorporation. The company must also submit a certified copy of the company's constitutional documents in its original place of incorporation as part of the application. This may be the company's charter, statute, constitution, memorandum, or articles of association, depending on where the company was originally incorporated. To prove that the requirement for members' approval has been met, a certified copy of the resolution duly passed under the overseas company's constitutional document and the law of the place of incorporation approving the company's redomicile, passed by at least 75% of the eligible shareholders, passed at a meeting or in writing, must be submitted to the Registrar of Companies. This document is required only if neither the law of the original place of domicile nor the constitutional documents of the company require shareholder approval of the company's redomicile. Applicants also need to submit a legal opinion from a legal practitioner qualified in the original place of domicile. Section 21F of Schedule 6C of the Companies Ordinance sets out a detailed list of confirmations that have to be included in the legal opinion, and these include that the company is duly registered and validly subsisting in its original place of domicile, that the company type and the original place of domicile is the same or substantially the same as the proposed company type subsequent to redomicile. Thirdly, that the proposed directors are not disqualified from being appointed as directors under the law of the original place of domicile. Fourthly, where there will be a change of company name, that the new name has been approved by the shareholders and the change of name will not affect its subsequent deregistration in the original place of domicile, that the proposed redomicile is allowed under the law of the original place of domicile, and that all permissions and/or shareholders' consents under the law of the original place of domicile and the overseas company's constitutional documents have been obtained. If neither the law of the place of incorporation nor the constitutional document of the applicant requires shareholder consent, a resolution has been passed by a majority of 75% approving the proposed redomicile. Seventhly, that there are no petition orders or proceedings to wind up or liquidate the overseas company. No person is appointed as the liquidator or receiver with respect to the overseas company or its property, and the overseas company is not operating any scheme, order, compromise, or arrangement relating to the insolvency of the overseas company. Eighthly, that the law of the original place of domicile allows the deregistration of the overseas company for the purpose of the redomicile. And finally, that the proposed articles submitted with the application have been duly approved by the shareholders of the overseas company by way of resolution. As part of the application documents, the overseas company is also required to submit its latest financial statements or audited financial statements containing financial information up to a date that's not more than 12 months before the application. In the consultation conclusions, the FSTB relaxed the requirement for the financial statements to be audited if the laws of the original place of domicile, the rules of the relevant stock exchange, or other similar regulatory rules don't require audited financial statements. The FSTB also stated that under the Companies Ordinance, companies must prepare audited financial statements annually after successful redomicile to Hong Kong. Under Section 2.2 of Schedule 6C of the Companies Ordinance, the overseas company must also submit a certificate issued by the Board of Directors, which is signed by a director, authorized by the board with certain confirmations, which include that the overseas company has one place of incorporation, whether the company's previously undergone redomicile, and that the overseas company is either duly registered in its original place of domicile or in the jurisdiction where the company has previously redomiciled. Thirdly, that the overseas company has not been notified of any proceedings or orders to wind up or liquidate the overseas company, and any appointment of any receiver or liquidator, and the overseas company has not passed any resolutions to wind up or liquidate the overseas company, and there are no schemes, orders, compromises, or similar arrangements that relate to the insolvency of the company. Fourthly, that notice has been served on all creditors. Fifthly, that all consent or approval for the redomicile and deregistration has been obtained. Sixthly, that the overseas company is not prohibited from deregistering from its original place of incorporation under its constitutional documents or the law of that place. Seventhly, that the proposed articles have been duly approved and adopted by the shareholders. Eighthly, that at least one financial year has passed since the overseas company's incorporation. Ninthly, the application is made in good faith and is not for the purpose of defrauding creditors. And finally, the directors, after making full inquiries into the matters of the overseas company, the board is of the view that the overseas company will be able to fulfill its debts falling due during the 12 months after the date of making the application. The documents required to be submitted as part of the application also include other documents, such as notice to the Business Registration Office, any applicable business registration fee, and an application fee. The one-stop business registration arrangement between the company's registry and the Inland Revenue Department will also apply to redomicile applications. In addition, the company's registry may also request further documents or information to assist them in determining the application. All application documents should be addressed to the Registrar of Companies, although the processing time for applications will vary according to the type and circumstance of the company. The processing time for the redomicile application is expected to be approximately 2 weeks. If the Registrar of Companies approves the non-Hong Kong company redomicile application, the Registrar of Companies will register the company as a registered redomiciled company and issue a certificate of redomicile. The company will be regarded as having redomiciled to Hong Kong on the date the certificate of redomicile is issued by the Registrar of Companies. Redomiciled companies must then complete the deregistration process in their original place of domicile and submit evidence of deregistration to the company's registry within 120 days from the date of redomicile. Under Section 820F of the Companies Ordinance, if a company fails to do so within that time frame, the registration in Hong Kong may be revoked, therefore deeming the redomicile application as unsuccessful. The Registrar of Companies may allow a time extension on the application by the redomiciled company and may impose any conditions as appropriate. The Companies Ordinance also stipulates a specific requirement concerning the consent of directors of a redomiciled company. Under Section 820G1, a statement of consent to be a director must be delivered to the Registrar of Companies for registration within 15 days of the redomicile date. This filing is required only if a person who has consented to be a director of the intended redomicile company did not sign the consent to be a director portion of the original redomicile form. The second critical filing post-redomicile is the return of particulars of members pursuant to Sections 820H2 and 820H3. A redomiciled company must deliver a return to the Registrar of Companies within 15 days after the redomicile date. This return must be submitted in the specified form, NSC 21, and must contain a statement of share capital and the required particulars relating to the members. Under Section 338A4 of the Companies Ordinance, a redomiciled company is required to deliver a statement of particulars of a charge to the registrar within 1 month after the redomicile date. This obligation arises in two specific cases. The first is where this requirement applies is when the company, while still incorporated overseas, created a charge before it became a redomiciled company. This filing is required only if the charge continues to subsist on the redomicile date and is of a type that would have been required to be registered under Section 335 of the Companies Ordinance had it been created by a company already incorporated in Hong Kong. The second scenario is when a company, while still incorporated overseas, acquired property in Hong Kong or elsewhere that was already subject to a charge, and the charge subsists on the redomicile date and is of a kind that would have required registration under Section 338 of the Companies Ordinance. For both scenarios, the required form is NM10, the Statement of Particulars of Charge for redomiciled company, charges before redomiciliation date. In instances where the charge is part of a series of debentures, Form NM8 may also be applicable. However, if the charge is already registered under the Companies Ordinance, repeated registration will not be required. A separate but unrelated filing obligation arises under Section 3411C of the Companies Ordinance concerning the issue of debentures. If a debenture forms part of a series that contains or gives a charge where every debenture holder is equally entitled to the benefit of the charge, and if a statement of the particulars of that underlying charge is required to be delivered for registration under Section 338A4, then a statement of the particulars of every issue of debentures in that series must also be filed. In relation to any issue of debentures made on or before the redomicile date, the statement must be delivered for registration within 1 month after that date. For any subsequent issues of debentures, the statement must be delivered within 1 month after the date of the issue. The specific form to be used is Form NM9, the Statement of Particulars of Issue of Debentures of a Series. Finally, Section 3421D2A of the Companies Ordinance applies to require the disclosure of any commissions, allowances or discounts paid in relation to debenture subscriptions if 4 concurrent conditions are met. The first condition is that a commission, allowance or discount has been paid or made either directly or indirectly by the company to any person in consideration for subscribing, agreeing to subscribe or procuring subscriptions for any debenture. The second is that the debenture in question creates evidences or is part of a series that contains or gives a charge. The third condition is that this charge was created by the company. The fourth and final condition is that a statement of the particulars of the underlying charge is required to be delivered for registration under Section 338A4. If all 4 conditions are satisfied, the redomiciled company has to deliver the statement in the specified Form NM10 within 1 month of the redomicile date. Regarding taxation, Section 820D4 of the Companies Ordinance says that when a company redomiciles to Hong Kong, it would not trigger a transfer of assets or a change in beneficial ownership. The process itself would not affect the company's tax liabilities in its place of original domicile or in Hong Kong. The company remains liable to pay taxes incurred in its original domicile and is subject to Hong Kong profits tax on any profits it earns or derives from the region, which is the position under the Inland Revenue Ordinance, which is that irrespective of the place of incorporation or tax residency, profits tax in Hong Kong is charged on profits arising in or derived from Hong Kong from a trade, professional business carried on in Hong Kong. Section 2(9) of the Inland Revenue Ordinance has been amended to specify that all references in the ordinance to a company established or incorporated in Hong Kong includes a company redomiciled to Hong Kong. This may impact tax residency and the application of tax treaties signed between Hong Kong and other jurisdictions. For example, under the amendments, redomiciled companies may be treated as resident in Hong Kong under the Avoidance of Double Tax Agreements or Arrangements, CDTA. Redomiciled companies can apply to the Inland Revenue for a certificate of residency status, stating that the company is a Hong Kong tax resident from the redomicile date. Schedule 1711 was also added to the Inland Revenue Ordinance, giving details of specific tax treatment for redomiciled companies. This schedule outlines how various expenses, expenditure, and the cost of trading stock incurred both before and after redomicile will be handled for tax purposes. To prevent double tax, sections 12 to 14 of Schedule 1711 provide for unilateral tax credits subject to certain limitations. These credits are available to a company where it has to pay tax on unrealized profit in its original domicile because of the company redomicile, and Hong Kong profits tax needs to be paid on the same profit after the redomicile. As regards stamp duty implications, since the redomicile process will not involve the transfer of the company's assets or shares, it would not give rise to a charge to Hong Kong stamp duty. The FSTB expects that many of the companies that will apply for redomicile to Hong Kong will be established companies with a place of business in Hong Kong that are already registered as non-Hong Kong companies under Part 16. As I mentioned earlier, one of the aims of the proposed redomicile regime was to allow companies to preserve their business and legal identity after migrating their place of domicile to Hong Kong. And in line with this policy intent, registered non-Hong Kong companies applying to redomicile to Hong Kong are allowed to keep their existing company name and business registration number after the redomicile process. The Business Registration Office will issue an amended business registration certificate on registration as a redomiciled company. For redomicile applicant companies who are not registered non-Hong Kong companies, the FSTB clarified in the consultation documents that filings and records of the company prior to redomicile are regulated by the law of the original place of domicile. the company would only be required to observe the record keeping and filing requirements under the company's ordinance from the date of its redomicile. Regarding companies with business operations in regulated sectors in Hong Kong, such as banks and insurance companies, the insurance ordinance and the banking ordinance have also been amended to specify that companies registered by the company's registrar as redomiciled companies and have completed the deregistration procedures in their original domicile will be treated as Hong Kong incorporated companies. The Legislative Council brief issued by the FSTB in December 2024 said that setting the timing as the time when the company is deregistered instead of when the company receives the certificate of redomicile will minimize complications where a company later fails to deregister and its redomicile status is revoked by the company's registry. In the insurance industry, a redomiciled insurer is defined in the insurance ordinance as a company that was originally incorporated outside Hong Kong and which later becomes a redomiciled company and has been deregistered in its place of incorporation and becomes an authorized insurer. Any non-Hong Kong authorized insurer looking to redomicile must first secure a letter of no objection from the insurance authority before they can submit their redomicile application. Also, the banking ordinance outlines a specific approval process for authorized institutions, their holding companies, and approved money brokers. These companies must seek prior approval from the monetary authority before submitting the redomicile application. The monetary authority has the discretion to approve or deny the application and can request any additional information if it needs to make a decision. After an authorized institution, a holding company, or an approved money broker receives its certificate of redomicile, it must promptly notify the monetary authority and provide a copy of the certificate. Once the company's completed all deregistration procedures in its original jurisdiction, it's required to notify the monetary authority again and submit documentary evidence of their deregistration. The banking ordinance also states that redomiciled institutions must still submit certain documents, such as audited balance sheets for periods before the redomicile, to ensure continuity and regulatory compliance. Other consequential amendments have been made to other sections of the company's ordinance, other subsidiary legislation, and other ordinances in Hong Kong to give effect to the redomicile regime. For instance, amendments have been made to the definition section of the company's ordinance to expand the definition of company to cover redomiciled companies and to explicitly exclude redomiciled companies from non-Hong Kong companies. During an FSTB briefing session, the Assistant Secretary of the FSTB said that the exchange has also dedicated staff to provide further guidance to and facilitate the redomiciliation of overseas companies listed on the Hong Kong Exchange. So that brings me to the end of this presentation. Thank you again for joining me, and I hope to see you again. Bye.